if we take it, if we proceed on the assumption that the basic idea of heck expressed in imprecise terms is to prevent end runs around habeas, and then we have a situation in which someone is charged with a minor offense with a small penalty and a high likelihood that no time in incarceration is going to be imposed, and all that would be done is maybe a small fine. And then years after, and this is done under a statute, under a particular statute, that like the one involved here. And then sometime later, the person brings a 1983 claim because that person wants to engage in what he claims is protected First Amendment activity going forward. Doesn't that seem quite far afield from what heck was trying to get at?
I don't think so, Your Honor, because again, I think the limiting principle is the as-applied challenge. He certainly could bring an as-applied challenge, but not only just because the plaintiff can't bring that facial challenge, his fellow protester has already brought the facial challenge in a separate lawsuit here. And facial challenges are disfavored anyway, and so the fact that we would not let someone impugn their prior conviction with a facial challenge, that's not anything out of the norm. I mean, I would like to emphasize exactly what the petitioner is asking for here. He's characterizing his suit as a pre-enforcement challenge. He says he wants a facial declaration of unconstitutionality in the face of a prior conviction while he was on probation. Any one of those four things individually would be disfavored under the law, and he's trying to do every one of them collectively in a single lawsuit. And so there's no historical or traditional basis to allow that.
Well, maybe he's wrong on the merits of the First Amendment claim, but assume for the sake of argument that he's right under the, on the merits. And I'm not suggesting in any way that that's the case. Assume that for the sake of argument. And now he wants in the future to be able to engage in conduct that he thinks is protected by the First Amendment. And doesn't it seem a stretch of the underlying reasoning, the rationale of heck to say, no, you can't ever do that. You're forever barred from engaging in what you think is protected First Amendment activity because you were previously convicted under this statute and received more or less a slap on the wrist.
He's not forever barred. He's only barred until he achieves a favorable termination, which would be relatively easy to get under Mississippi law for a first-time misdemeanor. And the limiting principle, again, is the facial declaration portion. Nothing would prohibit him from bringing an as-applied challenge. Nothing would prohibit him from doing different conduct than he was convicted to in the past. We're only talking about the drastic relief of a facial declaration of.
But as to that,